Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Thank you for subscribing to my YouTube channel. It helps me and it helps others that are also fighting foreclosure. If you do have a question regarding your own foreclosure, you can always send me an email to foreclosurehelp777@gmail.com, as it is written just like this. And also, I am not an attorney. I am a pro se homeowner who fought my own foreclosure, and I try to help others do the same. So again, if you have any questions, you can always shoot me an email and I'll try my hardest to answer your question. Today's topic is pretty important. A lot of people need to pay close attention to how they can sue their lender. So let's take a look at this. Okay, so let's go over the Bible verse of the day real quick, which is Leviticus 6:2. If a soul sin and commit a trespass against the Lord and lie unto his neighbor, and as you can see, we are talking about a breach of contract claim here. And actually, the mortgage contract, it's a contract, and the mortgage servicer can breach the contract. And we're going to go over this because a lot of people want to file lawsuits against their lender to stop a non-judicial foreclosure, and they need to have some kind of cause of action. And many times, the mortgage servicer will breach the contract. So let's look over how that happens. Leviticus 6:2 speaks of a breach of faith and dealing falsely in something entrusted to another. In mortgage servicing, a contract is also built on promises and obligations. The borrower has duties, but so does the lender or servicer. And when those contractual duties are ignored, payments are mishandled, notices are not given, or agreed protections are not honored, the issue is not merely poor servicing, it may be a breach of contract. So in foreclosure defense, a breach of contract is when the other side breaks the agreement. A foreclosure case may begin with an alleged borrower default, but that does not end the contractual inquiry. The question homeowners should ask: did the lender or servicer comply with the contract? Okay, let's get into the meat and potatoes of this. What is a contract? A contract is a legally enforceable agreement between parties that creates rights and obligations. At its most basic level, a contract tells us who promised what to whom. In mortgage litigation, those promises may govern payment obligations, application of payments, escrow, fees and charges, notices, acceleration, reinstatement, other rights and obligations. The starting point is always the actual language of the agreement. The mortgage loan is built on contracts. A mortgage transaction may involve several contractual documents. The promissory note, it contains the borrower's promise to repay the debt according to the stated terms. The mortgage or deed of trust secures repayment and establishes additional rights and obligations as concerning the property and enforcement. Loan modification. It may change the original contractual terms, including principal, interest rate, payment amount, maturity date, or treatment of arrears. Always determine which agreement and which provision governs the dispute. Always determine which agreement and which provision governs the dispute. Your notes make this especially important. With modifications, the original mortgage or an enforceable modification may together establish the operative terms. So what is a breach of contract? A breach occurs when a party fails to perform a contractual obligation without legal excuse. But this allegation is not enough. The servicer improperly serviced my mortgage. Ask instead, what did the contract require? What did the defendant actually do? How did those two things differ? A breach of contract claim must be tied to an identifiable contractual obligation. There are four basic elements. Although the precise formulation varies by state law, a breach of contract claim generally requires allegations establishing contract. Number one, a valid contractual obligation existed. Number two, performance. The plaintiff performed, substantially performed, or was excused from performance. Breach. The defendant failed to perform a contractual obligation. Damages. The plaintiff suffered legally cognizable harm caused by the breach. So the contract, performance, and breach and damages is what you want to look for. That is the core framework in your notes. Element number 1, identify the contract. Don't begin with what the servicer did wrong. Begin with the promise. Identify what document contains the obligation, what provision creates the obligation, who is bound by that provision, and what exactly does the provision require. A complaint becomes much stronger when it identifies a contractual provision allegedly breached rather than referring vaguely to the mortgage. Element number 2 is performance. A plaintiff asserting a breach generally must address his or her own contractual performance or a legally recognized excuse for non-performance. Questions may include: what was the borrower required to do? What did the borrower perform? What was the substantial performance? Was performance prevented or excused? Did the alleged breach occur before the borrower's alleged non-performance? We cannot skip this element simply because the servicer allegedly did something wrong. Element number 3, the breach. Now compare the contractual promise with the actual conduct. For example, contract required: apply payments according to the specified contractual terms. Borrower alleges payment was received but was not applied as required. The result, funds were placed in suspense, charges accumulated, and the amount was treated as delinquent. Now we have alleged facts describing the breach rather than merely the legal conclusion defendant breached the contract. This is exactly the distinction that your notes should make between conclusory pleading and factual pleading. Element number 4, damages and causation. A breach alone is not the entire claim. The plaintiff generally must connect the alleged breach to resulting damages. Ask, what happened because the contract was breached? Depending on the facts and governing law, alleged damages might involve improper contractual charges, misapplied or lost funds, foreclosure-related expenses, other monetary losses, other damages recoverable under applicable contract law. The critical connection is promise, breach, resulting harm. And your notes correctly flag breach and damages as areas where conclusory complaints can fall apart. The breach of contract test. Before alleging breach of contract, answer the 4 questions. Who promised what to whom? Where is that promise in the contract? And how was that promise breached? And what damages did that breach cause? If you cannot answer those questions with specific facts, investigate further before assuming you have a breach of contract claim. Let's talk about surviving a Rule 12b-6. That's a motion to dismiss if you're in federal court. If you're in state court trying to argue breach of contract and they remove it to federal court, they will try to have it dismissed under a Rule 12b-6. And so your object at that point is to survive the Rule 12b-6, motion to dismiss. Now, plausibility, not proof. At the motion to dismiss stage, the plaintiff generally does not have to prove the breach. The complaint must contain enough factual allegations to state a claim that is plausible on its face. Under Twombly and Iqbal, courts distinguish between factual allegations, which are generally accepted as true at this stage, and legal conclusions, which are not entitled to the same assumption of truth. The key lesson: you don't have to prove your case in the complaint, but you do have to plead facts that plausibly state the claim that tracks the distinction that identified in your notes. Conclusionary versus facts. Weak versus conclusory. Defendant breached the mortgage contract by failing to properly service plaintiff's loan and plaintiff suffered damages. What's missing? What's the contractual provision? What did defendant do? When did it happen? How was that conduct inconsistent with the contract, and what damages resulted? Here's a stronger, more factual. Paragraph 2 of the mortgage requires that the lender apply payments in the order specified by the contract. Plaintiff alleges that defendant received the plaintiff, and you can say any $sign there, payment on this date failed to apply as required and placed the funds in suspense, assessed and you can say how much that was in charges, and subsequently treated the account as delinquent. Now the court has facts to evaluate, yes. Connect the facts to the elements. Again, contract, paragraph 2 requires payments to be applied in a specific manner. Performance. Borrower alleged the payment of $1,500 on June 1st. The breach. Servicer allegedly received the payment but placed it in suspense instead of applying it as contractually required. Causation and damages. Borrower alleges that the account was treated as delinquent, contractual charges were assessed, and identifiable money loss resulted. That is plausibility that you need to survive that motion to dismiss. The plaintiff isn't necessarily proving that the plaintiff was misapplied yet. The plaintiff is alleging specific facts which, if true, support the elements of the claim. Plead the facts you know, use discovery to obtain the facts they control. Here's some case law, guys. And you can also Google some breach of contract claims. They're out there. Here's one from Tennessee. Filson versus Wells Fargo. This case details a successful breach of contract claim by borrowers against the mortgage servicer Wells Fargo for failing to honor an automatic payment service agreement, leading to a wrongful foreclosure threat. The court explicitly affirms the jury's finding that the servicer committed the first uncured material breach. The supporting paragraph, the mortgagors filed suit charging the mortgagee with a breach of contract for failure to comply with the terms of the note, deed of trust, and automatic payment service plan pursuant to the mortgagee agreed to automatically debit the mortgager's bank account for monthly payments. The jury found that the mortgagee guilty of breach of contract and awarded damages in the amount of $250,000. This matters because it confirms that a borrower can prevail against a servicer for administrative failures regarding payment processing, even if the borrower missed a payment, provided that the servicer's failure was the first material breach. And then we have Jenkins versus J.P. Morgan Chase Bank out of Tennessee. This case details a breach of contract claim against a mortgage servicer, J.P. Morgan Chase, where the bank lost the motion to dismiss, allowing the plaintiff's claims to proceed. Specifically, the court found that where the trial period plan, TPP, did not obligate the bank to modify the loan, the bank breached the TPP by initiating foreclosure proceedings while the application was still under review. The supporting paragraph states, accordingly, the court concludes that the TPP agreement constituted a contract, although it was not a contract where obligated Chase to modify the loan. The plaintiffs have sufficiently alleged breach of contract regarding the notification and forbearance and subsequent damages, including increased fees and interest relating to the decreased TPP payments, to withstand a motion to dismiss on these contractual terms. This matters because it establishes a legal precedent that a bank can be liable for breaching the procedural obligations of a loan modification trial plan, even if the loan is not ultimately modified. And the last case we're going to look at is out of Illinois, Saul Catalan versus RBC Mortgage Company, a 7th Circuit Court of Appeals decision where the court reversed a summary judgment in favor of a mortgage servicer on a breach of contract claim, allowing the borrower's case to proceed. The court held that the servicer's refusal to accept and apply tendered payments was a material breach, and that the borrower's alleged delay in payment was excusable due to the servicer's prior errors. The supporting paragraph states, to swallow GMAC mortgage argument, we would have to accept as a matter of law that a lender is free to refuse a tendered payment and then to hold the borrower responsible for having failed to make a payment. We do not accept that argument, whether or not GMAC mortgage delay in applying the plaintiff's payments was reasonable. It is an issue of material fact that precludes summary judgment for GMAC mortgage on that claim. A reasonable trier of fact could not a reasonable trier of fact could find that the plaintiff's failure to remit their October 2004 payment in a timely manner, although a breach of contract was excused due to the lender's earlier breaches and errors and the resulting confusion surrounding their account. Summary judgment for GMAC Mortgage on the plaintiff's breach of contract claim is reversed. Okay, guys, that does it for today's episode. I hope that this was informative. If you're trying to fight a foreclosure, whether it's non-judicial or judicial, you want to look at your contract and your payment history to see if your mortgage servicer has indeed breached your contract by failing to apply payments correctly. And as always, everyone have a blessed day.